Introduction Legislation Miscellaneous Amendments Bill 2013.
Members' motions. Motion under the Legislative Council Powers and Privileges Ordinance. Members who wish to speak on the motion will please press the Request to Speak button. I now call upon Ms. Cyd Ho to speak and move the motion. Ms. Cyd Ho. Thank you, Mr. President. I move that the motion as printed on the agenda be passed. Chief Secretary for Administration, we now meet again. Yes, we'd like to have more communication and have more meetings, but then we don't really want to see this be done on this occasion at such circumstances. Under such circumstances, we have to invoke the LegCo Powers and Privileges Ordinance in order to investigate the Chief Executive. Today's motion actually is a sequel to the motion moved by Ms. Claudia Mo in seeking the powers under the LegCo Powers and Privileges Ordinance to set up a select committee to inquire into the Chief Executive, Mr. C.Y. Leung, in selling the company DTZ, where there might be a conflict of interest involved in the contract that he signed. And today, I'm moving this motion. It involves the sale of some shares. That's about the options, the sale of options in the contract. And that was a contract signed on the 2nd of November 2011 in the form of a correspondence, and that was sent to Mr. C.Y. Leung, who had yet to become the chief executive, and there were £400 million which would be paid by 2 installments. And other than the fact that Mr. Leung would be receiving the second payment after he had assumed office, and there was also £1.8 million involved. That's about the 30% shares that he owned in DTZ Japan, and there was also this options which involved a delayed sale. And for the 30% shares was promised by UGL that no less than £200,000 would be spent to buy up that shares. And it's been said that actually the Australian firm was not making any profit at all, but then the UGL would pay him £200,000 on close, plus 30% of the net audited profit after taxation. And within 7 years, he would still be allowed to exercise those rights, and it was done at a very generous valuation. So that's before tax, and also that's before the calculation of profit. In fact, usually the dividend to be shared by each shareholder would be after tax and also after depreciation. But then this is a very generous arrangement. That is for the person owning the 30% share, that is C.Y. Leung, would not be required to be responsible for the depreciation and also the tax payment. That's why for the 30% yield that he could make out of that, when compared to the general shareholder, it would be a lot more. And also the pledge would be effective for 7 years. In other words, from the time when UGL acquired DTZ, it would be effective for 7 years. In other words, during the term of office for the chief executive, the value of these shares would be able to appreciate, and even if there might be depreciation, definitely that would not be lower than £200,000. That's why this is a very, very generous offer. But then we cannot but suspect that had the chief executive declared that to the Chief Justice under Article 47 of the Basic Law. In particular, for this part, has he declared the interest? According to our understanding, the Chief Executive said that such interests have been entrusted to a trust setup, and he had nothing to do with the dealings whatsoever. But then, for outsiders, we cannot but suspect that with regard to the decision to be taken by the trustee, it would very much depend on the trust documents. But then we have no idea as to what's contained in the trust document or instrument, and in particular, through an overseas registered company, that is a BVI company, a British Virgin Island company. Mr. Leung is owning 30% of this company, and it's only the shares owned by this registered company. But then he is actually covering up the interest through this BVI company, and the interest that has been hidden would be the 30% share that he owns in this company. And through media reports, we can also see that one of the major clients of DTZ Japan is the Hong Kong the HKR International Limited, and Payson Cha is also the second largest shareholder of ATV. And before the 30th of April 2014, he still owned a very large share of ATV, because back then he applied to the court to go after ATV for this warrants, and just the interest would come up to some $90 million, and he was asking for the he managed to get $200 million in order to resolve the case. So, in denying the issue of a license to HKTV, objectively, that would not cause any competition to the ATV, expediting the collapse of it. That's in October 2013. In fact, at the time, Mr. Payson Cha was still a major shareholder of ATV at the material time. Given the very complicated or intricate relationship, and only on the 9th of October, when the whole thing was exposed by Fairfax Media in Australia, that we were able to learn about this. And only then did we find out that together with the annual remuneration, together with the benefits, he only managed to get some $5.08 million a year. But then under the contract with UGL, he managed to get a payment equivalent to 12 years of remuneration as the chief executive of the SAR government. Other than the $4 million as suggested by Ms. Claudia Mo last week, he also got £200,000 on top of that. And despite the huge interest that he received, we had no idea as to whether or not he had declared the interest in accordance with the rules and procedures. All right, we have been told by the administration that this is not classified as assets. That's the CS replied to Mr. Albert Ho on the 29th of October. He said that under the basic law, there was no specific definition as to what's meant by asset, and as cash is not a declarable interest. That's why she's not able to tell us whether or not that was declared or not. But then, Mr. President, you were also in the Bills Committee when we debated or scrutinized the anti-terrorist law, and we also debated about whether cash should be defined as liquidity or assets, and subsequently we decided that the term assets should include non-liquid assets, including the dividends that you get from shares, and also jewelry and so on. So in the laws of Hong Kong with regard to the term assets, we do have this definition. Yes, under the basic law, it might not have got very specific definition about this, but then as the chief executive, has he acted in strict accordance with the existing laws of Hong Kong concerning the definition of assets by declaring all the assets under him? Well, even up to this day, we have no idea as to whether or not he has done so. Yes, on different occasions, the chief secretary has given replies to this, both in this council and outside this council. But then I hope that the Chief Secretary can be more specific today in your reply to us. All right, in the information that you prepare for this debate, have you got a very clear definition about assets according to our common sense understanding? Well, within the 7 years, if he's able to realize that into cash, then that would definitely be classified as part of his assets. That's why if a civil servant is in debt, he will have to declare everything. How come for the chief executive, how come he is above everybody else by not being required to declare such interest? And therefore, I hope that the chief secretary for administration can give us a detailed explanation. And also, this contract would also include areas which would give rise to a lot of skepticism. In fact, last week, many pro-establishment members have said that this is just a golden handshake agreement. Why are you trying to demonize the whole thing? But then, as a normal acquisition deal, well, when one of the parties is the senior management and also a director of the company concerned, then even if you were to offer him this golden handshake, it should have been included in the acquisition contract so that the entire board would be made aware of that, and even minor shareholders would also have a chance to know about this. But then this is not a tripartite contract at all, i.e. it's not the UGL, the DTZ board, and also CY Leung's contract. It's only an agreement between UGL and CY Leung. Between the two of them, they signed this contract, and it's also done in a haste within a very short space of time. So he was required to sign this back within a very short space of time. If you look at the letter together with the copy of the letter, all right, we have this cover letter, and it was dated December the 2nd, 2011. It was issued to CY Leung, and in the enclosure, he was given a deadline before which he would have to sign it back, and the English version reads,
and return it to me by no later than our deadline for this transaction close, which is 11 p.m. Sydney time on 2nd December 2011. 其實呢個協議
In other words, if you look at this contract, it's very hastily signed because, well, the deadline would be 11 p.m. on the same date, and he was required to sign it. We don't know when he signed it, and if you look at the time gap between Hong Kong and Sydney, there is a 4-hour gap. In other words, if you translate it into Hong Kong time, that's about 7 p.m., by which he would have to sign this contract and send it back to UGL. In other words, he only had a few hours to consider this. So when we look at the time line, so that's between the two parties, and if it had been a golden handshake, it would not have been done that way. Mr. President, this is most unusual. Ms. Cyd Ho, as you just pointed out, this council had already debated this, and we already cast our vote on Ms. Claudia Mo's motion under the LegCo Powers and Privileges Ordinance. She moved another motion, and I approved your motion today. That's because today's motion, despite the fact that it's also seeking approval to set up this select committee to investigate or inquire into Mr. CY Leung's interest, but then the substance is different from Ms. Claudia Mo's motion. That's why in dealing with today's motion, I urge members to try not to repeat what you have said last week in debating the motion moved by Ms. Claudia Mo's motion. Yes, I'm aware of that, but then if you look at the timing or the deadline before which the chief executive was required to sign it and send it back to the UGL, I think that would apply to both situations. That's why I will have to elaborate on that too. Also, Mr. President, this is a bilateral agreement, and this is most unusual. And if you look at the interest between the two, just now we talk about Payson Cha. He's the major shareholder of ATV. But then if you look at the conflict of interest, it's not just confined to the issue of license to HK TV, which might benefit ATV. And in fact, if you look at the interests of HKR International Limited, there are two other interests involved. First, HKR International Limited is the major shareholder of Discovery Bay, and when we try to advocate for the development of East Lantau, any action or inaction on his part might constitute a transfer of benefit. Why? That's because if you look at HKR's dealings in Japan, well, they engage DTZ Japan to do it. So one of the major clients of DTZ Japan is HKR, and therefore, if the 30% shares of CY Leung have to go up substantially, then there is an incentive on his part to promote the business of DTZ Japan. And one of the ways to make more profit is to do something in making public policies in Hong Kong so that certain policies would benefit HKR. And last week, Mr. President, other colleagues have also repeated this, and there were many justifications put forth by members. And in order to avoid a repeat of what's been said, I would ask members not to read this out again. That's about the facts involving the Pan-Democrats receiving money. I hope that you can come up with some new justifications or arguments, and then I'll leave it to the time remain during my response to respond to that. Thank you.
And I propose a question to you, and that is that the motion moved by the Honourable Cyd Ho be passed. As what I've pointed out to Ms. Cyd Ho, this Council has dealt with another motion moved by Ms. Claudia Mo under the Legislative Council Powers and Privileges Ordinance. The motion today involves accusations of acceptance of advantage on the part of the Chief Executive. Your debate should not repeat issues already touched on in the last debate. This is not about the content or justifications. Rather, we should not focus on issues already debated and handled and decided in the last debate. So just a reminder. I'll invite the Chief Secretary for Administration to speak. Mr. Albert Chen, President, can you please do a head count? Chief Secretary for Administration. Silence, please. CS. President, Ms. Cyd Ho seeks to move a motion to appoint a select committee to inquire into whether the Chief Executive of the Hong Kong SAR, Mr. Leung Chun-yan, has contravened Article 47 of the Basic Law and whether he has reached any conflict of interest. Once again, on behalf of the administration, I oppose the motion. Ms. Cyd Ho's motion is still, in fact, about the resignation agreement signed between Mr. C.Y. Leung and UGL. I must point out that there have been enough and ample debates on this matter in this council already. On the 29th of October, Mr. Albert Ho asked an oral question, which I gave a detailed reply. And earlier on, Ms. Claudia Mo invoked the LegCo Powers and Privileges Ordinance to appoint a select committee to inquire into this matter, but the motion was defeated on the 17th of October and the 11th of November by the House Committee and the Council, respectively. Regarding Ms. Cyd Ho's motion, today it was vetoed by the House Committee on the 31st of October. Since the administration has responded a number of times, I will not repeat the details of the matter now, but having heard Ms. Cyd Ho's speech for more than 10 minutes, I have the feeling that she's used a lot of imagination, or she was wearing a pair of tinted glass in interpreting the relevant agreement, giving rise to unbiased accusation and allegations. In my beginning remarks, I would just like to reiterate a few points. First, the agreement between Mr. Leung and UGL was in fact a non-compete agreement, which was to ensure that Mr. Leung would not move to a competitor, set up or promote any business in competition with DCL or poach any people from DTZ to protect the interests of the vendor. As said by members, it is in fact a very common commercial agreement. And as confirmed in UGL's public statement, the DTZ Holdings and also Royal Bank of Scotland were fully aware of the resignation agreement, so there was nothing confidential about it. And then it was confirmed by UGL's statement that Mr. Leung has not provided any service to UGL after signing the resignation agreement. And Article 47 of the Basic Law stipulates that the CEO on assuming office shall declare his or her assets to the Chief Justice of the Court of Final Appeal for record. And the LegCo has a set of very stringent system for declaration of interest, which the CE has strictly observed, and therefore I see no reason why a select committee should be appointed to inquire into this matter. I'm against this motion. I will reply later. Thank you.
Mr. Chung-kai, thank you, President. I support Ms. Cyd Ho's motion that this council should appoint a select committee to inquire into whether the CE of the Hong Kong SAR, Mr. C.Y. Leung, has contravened Article 47 of the Basic Law, which stipulates that the CE must be a person of integrity, dedicated to his or her duties, whether he had accurately declared his holding of shares in DTZ Japan to the CJ of the CFA of the Hong Kong SAR when he assumed the office, and whether the gains from his shares have constituted any conflict of interest with his performance of the duties of the CE, including but not limited to not issuing a domestic free TV program service license to Hong Kong Television Network Limited and other related issues. And that in the performance of its duties, the committee be authorized under the LegCo Powers and Privileges Ordinance to exercise the powers conferred by Section 9(1) of that ordinance. I'll follow your instructions, President. I will try not to repeat the points made during the debate moved by Ms. Claudia Mo, but then I think the background is rather similar. Now, the secret agreement signed by Mr. C.Y. Leung and UGL has triggered a lot of public concerns. On the 5th of November, Ms. Claudia Mo moved a motion, and but
to inquire into his conduct, but then the pro-establishment members voted down the motion. And here we're talking in this case we are talking about the CE's credibility. He has received 4 million pounds from UGL Limited. No, we do expect the CE to put society's interests first and foremost in formulating policies. So we query his integrity and also the fact is that he hasn't made the declaration. In fact, before the motion debate on the 5th of November, the CE met a selective few LegCo members, all from the pro-establishment camp. In fact, CY Leung should give a full account not only to pro-establishment members but to all members of the public. Under Article 47 of the Basic Law, the CE has the responsibility to declare his or her assets. In 2011, the CE stood for the CE election. He had signed an agreement with UGL before that, but then when he assumed office, he did not terminate the agreement. The agreement states that CY Leung has a duty to discharge certain duties towards UGL. But then, as we can see from Article 47 of the Basic Law, the CE must be a person of integrity. And one can't help suspecting whether he may put UGL's interests above public interest. Concerning the 4 million pounds offered by UGL, part of it is for acting as referee and advisor to the UGL from time to time. CY Leung has said that he has not provided such service to UGL, but then in fact the amount is remuneration and may be subject to salaries tax. I think you are repeating what you said last time. Sorry. Now, there is this company called Wintrack Worldwide BVI, and it owns shares in DTZ Japan. When CY Leung assumed office, as members will recall, one of his tasks was to consider the issuing of free TV service program licenses, and we know Mr. Pt1 was involved in ATV business, and so was there any conflict of interest on the part of the CE? Did he try to protect or defend Mr. Cha's interests in considering whether to issue a domestic free TV program license to HK TV Network Limited? Now, concerning this BVI company, we don't know or we didn't know what the interests behind were until there was the media report on the deal between CY Leung and UGL. And I think a thorough investigation is required when faced with an allegation of potential conflict of interest. CY Leung said that Wintrack merely held shares in other companies, and Wintrack itself didn't have any business operation. But then what about the companies owned by Wintrack? CY Leung did not give the whole story. why didn't he say that Wintrack in fact held DTZ Japan shares? Why didn't he tell us what business DTZ Japan was involved in? Why was it that Cyd Leung was not forthcoming? At that time, we just asked whether Wintrack had business in Hong Kong or in the mainland. But then, in fact, subsequently we knew that Wintrack had business in Japan, and one of the clients was Mr. Charles' company. So with regard to the overseas branches of DTZ, we now know what business they are involved in, and so we can't help suspecting that Cyd Leung deliberately concealed his shareholding in DTZ Japan. And so Ms. Ho is today asking members to set up a select committee to look at whether there was any conflict of interest concerning the CE's consideration about issuing domestic free TV program service licenses. We want the CS4A to tell us whether at the LegCo meeting Cyd Leung discloses interest in DTZ Japan. Now, during all the meetings of the LegCo to discuss domestic free TV program service licenses, did Cyd Leung disclose his ties with Mr. Payson Cha? On the 15th of October 2013, HKTV Network Limited was informed that a license would not be granted, and in fact that was in fact contrary to the recommendation of the Communications Authority. At that time, it was said that there 2 other licenses would be issued. And for the CA proposed to LegCo that 3 licenses could be issued. In fact, before 2012, before Cyd Leung assumed office, the former LegCo had discussed the matter, and it was said that Donald Tsang had decided deliberately to leave the matter to the Leung administration. So in 2012, Cyd Leung assumed office. And in the following 15 months, LegCo discussed the issue of TV licenses on a number of occasions. And did Cyd Leung declare his interest in DTZ in detail, or DTZ Japan in detail? On the website, we were able only to find Leung's declaration with regard to his stakes in Wintrack Worldwide, and nothing was mentioned about DTZ Japan. So was it that Cyd Leung was deliberately trying to conceal his conflict of interest? Because if he had declared his interest, he would not have been allowed to chair the meeting, and as a result, he could not have exerted his influence to finally issue 2 instead of 3 licenses. We hope that the CS4A can, in her reply, give us the details. At the end of August, in the judicial review lodged by the HKTV Network Limited, LegCo meeting minutes were disclosed, and we could see that in fact the Secretary, Mr. Greg So, supported the issuing of 3 licenses, but then Cyd Leung didn't want to issue 3 licenses, and Cyd Leung decided against issuing 3 licenses. He was in favor of issuing only 2 licenses. In fact, the licensee, this applicant, which didn't come last, was rejected, and it was only in July 2013 that Leung declared that he would transfer his stakes into a trust. So for 1 year, he owned Wintrack Worldwide, and Wintrack Worldwide owned DTZ Japan. So during this period, during the first year of his office, was he involved in the management of DTZ Japan? Apart from being a shareholder, did he do other work for DTZ? It was in July 2013 that he completed the transfer of the stakes in Wintrack into a trust. And then 3 months later, beg your pardon, he decided not to issue the third free TV program license. So we need to find out whether C.Y. Leung has tried to hide his interest in respect of DTZ Japan and also ATV and also Mr. Cha. So we hope that a select committee can be set up so that we can have access to the LegCo minutes, and so that we will know whether C.Y. Leung did declare his interests. I understand, President, that this motion will be voted down. We are used to our motions being voted down. But then I think justice is in our hearts. C.Y. Leung was an adjudicator for a WKCD competition, and that was the first occasion when members wanted to hold an inquiry into his conduct under the PNP, and Claudia Mo moved a motion, and now today we have this motion from Cyd Ho. Now, it is not that we are trying to stir up trouble, President. If he had not, or if he had been a person of integrity, if he had not given rise to such suspicion, we would not have wanted to resort to the LegCo Powers and Privileges Ordinance to inquire into his conduct. Thank you.
Ms. Claudia Mo. Thank you, Mr. President. President, we often say that everyone is equal before the law. But then when we make such remarks, we should not put too much emphasis on it, because even if you commit the same offense, well, let's say if it's an indecent assault case, and if the defendant is convicted, or if he pleads guilty, then whatever his status, whether or not he's just a tutor or a teacher or a priest or a referent, well, actually it would be an aggravating factor, because you've actually let down the trust placed on you by the victim. So the word trust, we often say that before the media, everybody is equal. Of course, that's not true, because for an ordinary passerby, if he holds an amplifier, nobody would be bothered. But then if it's the chief secretary for administration or the president of this council, if you want to meet the media, everybody would rush to meet you. That's because of your status. That's because of your social standing. And basically, the entire community of Hong Kong would have this basic trust in you. And therefore, what we are talking about is the entire city of Hong Kong. We are talking about the chief executive of this city. So he's supposed to be the one holding the largest public power in his hands in Hong Kong, and yet this person is subject to a lot of skepticism. There are so many ambiguities surrounding him, and yet he cannot be bothered. He's just taking this as if nothing had happened. All right, if it's a news about Mr. Chen next door having a mistress, then why would you be bothered? What kind of public interest is there? why would there be any public interest in it? None. But then assuming that, Mr. President, if you have a mistress, well, just assuming that you had this, this is not meant to be offensive. It's just because of your status and because of the power that you hold in your hand. That's why it would attract a lot of public attention. So we're talking about whether this guy has abused his power, and yet he cannot be bothered. He doesn't even want to he doesn't even want to come here to explain. All right, sometimes it's the chief secretary, and then at other times it would be a bureau director. And this morning we have the Secretary for Financial Services and the Treasury answering the question raised by Mr. Chung-kai. It's about the same contract. Yes, Mr. President, I understand that you asked us not to repeat the arguments that we had made on previous occasions, but then basically we are talking about the same contract. We are talking about the same incident and involving the same person. And what we are questioning is the integrity of this person. So inevitably, we will have to repeat some of the arguments. This morning, we asked him about salaries tax and also profits tax. And the profits made should be taxable, but then he just makes a few statements saying that on confidentiality and privacy, we are not supposed to comment on individual cases. We are not talking about passers-by ABC. We are not. It's not just about major public interest. It's actually about whether or not there is a propensity to commit crimes or offences. In the UK, in Australia, they're actually investigating this as a criminal case. And assuming that C.Y. Leung has come clean on this, if he said that there were two places that are investigating him and he's involved in this case, and as a person being investigated, it's not appropriate for him to make statements or to make remarks about this. All right, in the US they say this, and we would be prepared to understand it. But then we are not just talking about lawfulness. We also have to be reasonable and be able to stay close to the reality. All right, you said that on confidentiality rule, you're not able to disclose anything and your assets have nothing to do with this. But then it's said reasonable is, well, as the top policy maker in a city, you have all the powers in your hands. Are you doing justice to the city by doing so? And under the basic law, it's spelled out very clearly under Article 47. It says that the chief executive must be a person of integrity dedicated to his or her duties. All right. These are the words succinctly summarized in the basic law, and it sounds like a platitude. But then if you look deeper than the words, you will have to do it. In particular, if you look at the English version, Article 47 of the Basic Law, it has not been translated literally. All right. As the chief executive, you have to be a person of integrity. You have to be a person of integrity. So it covers everything. You have to be a person of integrity. All right, this is very plain in black and white. And then on different occasions, he just asked someone to read out the script on his behalf, and then that's it. But then history will record it. It's not that we have nothing better to do. That's why we are trying to dig out something to debate, and therefore there might be a political motive behind it. I couldn't remember. Probably it was Ms. Dari Lee from the pro-establishment camp. She said that plainly there was political interest involved or political motive. All right, this council is about politics. What else are we doing here? So we are here to monitor the government to make sure that it doesn't make any mistakes. Mr. President, Ms. Cyd Ho's motion specifically referred to HKR International, and there are a lot of intricate ties and relationship. And of course, with yesterday or last night's experience, all right, HKTV finally managed to launch its programs, but then it's just an online TV network, and it applied for a TV license. It was denied a license, and therefore it is now making a fresh application. Let's see how things will unfold. All right, they then applied for a mobile TV license, and it was again rejected. And now they are running this online TV broadcasting service. So Hong Kong TV's relationship with CY Leung, again, if you look at this contract, you may think that we are mixing everything up, or you may say that there are intricate links with this. All right, people would say that when I chatted with my friend about this contract, among the very specific or tedious details contained in this contract, and they said that it's a bit convoluted. And if that's the impression that you have, then the person involved should have come forward to tell us everything. Instead of asking Carrie Lam to sit here, he should have been here himself. All right, just on this, I think all he needs to do is to come clean on this. All right, that's the historical background, and then what's going to happen next. Why don't you just come clean on it? Tell us everything about this. Why are you not prepared to disclose the issues here? All right, you just said that it's far-fetched. You've allowed your imagination to take you too far, but then there are reasonable suspicion. It's not that we are engaging in a pre-trial. In fact, we'd like to set up a select committee to look into this, and if you're able to come clean on this, if you're able to disclose everything, then it doesn't matter if we set up this select committee. Well, even if we do not have this select committee, it's just a very plain and straightforward matter. But then if you look at what has happened, this is really shameful. As a chief executive, you're actually hiding behind your subordinates, and you've never been able to come clean on this. You just read out a statement, and then you would just sit down. I've never seen Carrie Lam appearing so sad, because in the past when you look at her, she would put on a smiling face, and this mess has nothing to do with her. And now she's been made to read out this script, and then all the accusing finger would be pointing at her, and then all she could do is to read out the statement, and in a moment obviously she would be doing the same, and then she would say that these allegations are totally unfounded, and you have distorted the whole thing. This has never happened, and you have political motive behind what you say. Well, are you able to have your hand on your heart and have a good night's sleep? All right, if you're stating the facts, then why don't you ask CY Leung to come forward to state everything? If you're prepared to do it, then why don't you do it himself? Why doesn't he do it himself? All right, why don't you come forward and hold a press conference? You should not just be clarifying things in this council. You should have come forward. You should have held a press conference, and there should be live broadcast. Even if it has to last for 3 hours, you said that it's very complicated and Hong Kong people might not be ready to understand it. Why don't you have a PowerPoint presentation? You can also explain that slide by slide, and then that would be very clear. Instead of just meeting some representatives from the pro-establishment camp and say that, all right, I've done the explanation and I would not do anything further. This is really something that would make Hong Kong people see for themselves that we had such a deplorable leader in the city. This will not just end here. Definitely, it will never end. We are going to invoke this impeachment procedure. Let's wait and see what is going to happen. Thank you.
Mr. Tony C. President, earlier this month, a member invoked the LegCo Powers and Privileges Ordinance to appoint a select committee to inquire into matters related to the resignation agreement between CY Leung and UGL. The motion was defeated again. Another member used similar excuses to query whether the chief executive has declared his shareholding in DTZ Japan to the Chief Justice of the CFA, and whether there is any conflict of interest with his performance of the duties of the CE. LegCo is asked to invoke our powers and privileges to appoint a select committee to inquire into whether the CE has contravened Article 47 of the Basic Law, which stipulates that the CE must be a person of integrity. I am of the view that such motions has a political agenda, and that was admitted by a member just now. And of course, all members in support of such motions have the same objective. In particular, we have many social and livelihood issues being politicized. The CE is the target of attack by the opposition camp, thinking that by attacking the CE, that's the only solution to problems. Even without good justifications, the opposition camp would make use of all possible opportunities. It was so not long ago, and it's just the same this week. In particular, they have launched a non-cooperation campaign at this council and started filibuster, causing a lot of confusion in this council. Ms. Claudimo, I didn't hear you. President, I asked for a quorum call. Mr. Xi, please pause.
謝偉銓議員。
Mr. Tony C. President, I was saying that the opposition camp would make use of any opportunity they can to attack the CE. It was the case not long ago, and it's just the same today. What's more, they have launched a non-cooperation campaign and filibustering in this council, causing a lot of inconvenience and confusion in this council, bringing a lot of problems to the community. Myself and friends and professionals are of the view that this must not go on anymore. And because there isn't sufficient justification in this motion, and therefore I will not support an inquiry invoking our LegCo Powers and Privileges Ordinance. My vote is also my opposition to this attitude and this non-cooperation undermining the interests of society. Earlier this month, Ms. Sari Lee spoke on another motion trying to invoke the LegCo Powers and Privileges Ordinance to inquire into the conduct of the CE. I agree with what she said. Under the Basic Law, the Chief Justice of CFA is a person to monitor or to ensure that the CE is a person of integrity, dedicated to his duties. The CE has to declare his assets to the Chief Justice and not to LegCo. By the same token, an inquiry into whether the CE has seriously breached the law and or been dereliction in its duty is the function of the Chief Justice. The role of the LegCo is to move a motion to entrust the Chief Justice of CFA to set up an independent committee when there is sufficient evidence and good justifications, and then to decide whether we should impeach the CE, having considered a report by the Chief Justice. The relevant arrangements are clear enough since the Basic Law has set out the role of the Chief Justice and an independent inquiry to be led by him in ensuring that the CE is a person of integrity and dedicated to his duties. And if someone in this council has forgotten the basic design and arrangements of the Basic Law, I think they should get themselves familiar with the Basic Law first, rather than invoking the LCPNP Ordinance lightly, asking for inquiry into the CE. Regarding the content of the motion, once again, it queries whether the CE has declared certain assets to the Chief Justice. In fact, Mrs. Carrie Lam, the Chief Executive for Administration, has said a number of times that the CE has declared his assets to the Chief Justice of the CFA of the Hong Kong SAR under Article 47 of the Basic Law, and the declaration has been put on record. We must strike a balance between the CE's privacy and public interest. Such reports are confidential in nature. I think some members of the public and the opposition camp may have a division of view when it comes to how the CE deals with certain matters. They may not have enough trust in him, but I believe the majority of the community are of the view that such mistrust or distrust should not be the ground for accusing that the CE has breached the law. Since such accusations are very serious, and therefore people who have advanced such allegations and suspicions must provide sufficient evidence and justifications. Otherwise, we will say that such accusations are frivolous and without grounds. The declaration system has struck a right balance between protecting the CE's privacy and public interest, and it has been well established. We should give every respect to such a system unless we have good justifications to say that the relevant system is already damaged or has defects or no longer appropriate for nowadays. Otherwise, I see no reason why we should challenge if the mechanism is operating effectively. Another point in the motion is whether the CE has any conflict of interest in the matter of issuing a domestic free TV license to Hong Kong Television Network because of its shareholding in DTZ Japan. Some members say that because the CE holds 30% of DTZ Japan, and because this company has business dealings with HKR International, whose owner also holds shares in ATV, and some members questioned whether there is conflict of interest. In fact, HKR International issued a statement on the 12th of October saying that the whole thing has nothing whatsoever, has no conflict of interest whatsoever, and I don't see any good justifications supporting such accusations. If the opposition camp is trying to use this motion to express their distrust and dissatisfaction for the CE on trying to achieve some political aims, I believe they will not have the support of the majority of the community. With these remarks, I oppose the motion.
Ms. Starry Lee, President, within less than a month, this council moved a second motion to appoint a select committee to inquire into the CE's conduct. Now, they haven't provided any new information. They haven't been able to provide a prima facie case. And so the DAB cannot support the idea of making use of the LegCo Powers and Privileges Ordinance to turn this council into an open court to overthrow C.Y. Leung. Ms. Claudia Mo earlier on moved a motion to set up a select committee under the LegCo Powers and Privileges Ordinance. I want to point out that the LegCo Powers and Privileges Ordinance should only be invoked upon when on very important issues of public interest, and I don't think we are faced with this situation today. And then secondly, LegCo is not the appropriate authority to investigate the CE. In fact, we have an impeachment mechanism provided for under Article 73(9). If it is necessary to invoke upon this mechanism. With regard to the declaration to the CJ, the content is kept confidential. The purpose is to strike the right balance between public accountability and privacy. But then, there is some information available on the CE's office website available for public inspection. The stakes in Wintrack worldwide and the subsidiaries as well as the shares in DTZ have been transferred into a trust, and the trustee in fact is an accountant. And so I don't see any irregularity in this regard. If members have queries, they can follow up through other channels. Of course, they are entitled to ask questions, to raise their queries, but then I don't think there is a case in invoking upon the LegCo Powers and Privileges Ordinance. And concerning the alleged conflict of interest, there was the CE holding 30% of the shares of DTZ Japan through another company. In fact, 30% shareholding can't really have a say. And also DTZ is only responsible for valuation of property. And so concerning the main clients are those holding property, and it's just natural that Hong Kong R is one of its clients.
If on this basis there is doubt on Mr. C.Y. Leung favoring any client such as HAR, this is unfounded. There is no prima facie evidence. DTZ Japan or DTZ does not have any shares of ATV. If you extend the argument to say that the chief executive should be investigated because of this, and it is unreasonable. Furthermore, since Hong Kong R is responsible for property projects in Lantau, yet the interest is stake. So it is again unreasonable to suggest that C.Y. Leung favors the client. Well, the onus lies with the investigating party, and there is slim evidence to suggest any irregularity. There isn't even prima facie evidence. If we allow the exercising of the powers under the LegCo PNP, then that it would be a great waste of public money and time, and the reputation of the Legislative Council will also be at stake. Well, the background and the information in relation to this motion under the LegCo PNP Ordinance are by and large the same as the motions at previous meetings. The motion stemmed from speculations arising from C.Y. Leung's former post in the DTZ. The opposition camp is just trying to rely on the LegCo PNP Ordinance to investigate into the chief executive to make the government popular. It is just one of the tactics under the uncooperative campaign. In fact, at least there have been 4 such motions against the chief executive, and the DAB is against it. As I said just now, Mr. President, Legislative Council is not the appropriate investigating body in this matter. The Chief Justice, if an investigation is necessary, should set up a select committee select a committee for the purpose. The independent committee led by the Chief Justice has a high reputation, whereas if we set up a select committee, political or members with clear political stance would be chairing the committee and intervening with the whole process. So how can we ensure an impartial investigation? From the first day onwards, the opposition camp have been relying on different tactics, such as these motions, vote of no confidence, etc., to affect the governance of this administration. And there have been infights going on in this council. The non-cooperative campaign has equally heavy negative impact on our society as the occupation movement. I appeal to members of the opposition camp once again that they should not be uncooperative. They should call to a halt this whole destructive, non-cooperative campaign so that the LegCo's operation can be resumed.
Mr. Christopher Chung. Mr. President, 2 weeks ago, Ms. Claudia Mo proposed in Council that we should invoke the PNP Ordinance to investigate into Mr. C.Y. Leung's acceptance of benefit from UGL, an Australian company, before assuming office. It was not carried, and Ms. Cyd Ho is having a second bite of the same cherry, that we should again invoke PNP to investigate into the UGL incident, that the refusal of license for Hong Kong TV is the product of the CE's prejudice. In fact, it's really the same accusation. You are relying on flimsy evidence, so-called evidence, and to attack the CE by standing on high moral ground or moral high ground. This is also part of your uncooperative campaign. Ms. Cyd Ho's accusation has to do with Mr. C.Y. Leung's holding of 30% shares of DTZ Japan through a trust, and also DTZ Japan has a business connection with HKR International, partly owned by Raisin Cha. From 2009, Hong Kong R International has engaged DTZ Japan to do property management for 5 years. And in scrutinizing the application for a license by Hong Kong TV, that the CE has been biased towards ATV held by Raisin Cha. And it is said that C.Y. Leung and DTZ and also Raisin Cha has this subtle triangular relationship. But again, this will not stand a close look and a test. C.Y. Leung holds 30% of DTZ Japan, but Mr. Leung has already said that after assuming office as CE, the assets have been put into a trust. In other words, he is not directly involved in the business of DTZ Japan. And whatever business DTZ Japan is involved in has nothing to do with the CE. And the CE's assets have been declared well early on. And DTZ Japan has said that there is business dealing with HKR International. Now, does it mean that CE must therefore give preferential treatment to ATV held by Raisin Cha? I think if you know how business is done, you will know that someone can hold two companies at the same time, and the two companies may not have any subordination to each other. They can be quite independent entities. And Hong Kong R International issued a statement to respond that it doesn't have any relationship with ATV whatsoever. Now, may I repeat from that statement? Start of quote. In commissioning any consultancy, we use the principle of justice and fairness, and we will look at the professional standards and also reputation within the industry. As a listed company, the Hong Kong R International always goes for the highest level of governance, and its daily operation is independent and has nothing to do with ATV. End of quote. And as a magazine saying that it is exposing the matter, the amount involved is only like $1 million. Mr. Raisin Cha has invested billions of dollars into ATV, so the two are really quite different.
And also, with regard to the application of a free-to-air license, Hong Kong TV was not the only candidate. If there has been any bias towards ATV, there should not have been the issue of any free-to-air licenses because that would benefit ATV most. However, in October last year, the administration announced that there would be the issue of 2 free-to-air services licenses. It's only that Hong Kong TV was not given a license. As to why the Hong Kong TV was not chosen, the official side has already given an explanation, and that is the capability of the free-to-air TV market to have sustainable development because the market may not be able to sustain the number of TV licenses which would exceed 2. I wouldn't like to repeat things past. Hong Kong TV, in fact, has already started a court case about the denial of a license to it. I don't think other people should actively comment on the case now. Of course, in October, those 2 licenses were issued, but progress has been very slow. I think the administration has the responsibility to discuss with the 2 licensees that they should start operations soon, so the local free-to-air television scene can enter a new era, so people have more choices, and if there is stronger competition, we can have more high-quality programs. I'd like to emphasize that I belong to BPA, and I cannot see why we should make use of the trump card, which is the PNP Ordinance, to investigate the CE. Mr. President, I do not support using or applying the conspiracy theory all the time, but since the Pan-Democrats would always apply that theory on the CE, shouldn't we also say that in fact they had wanted to make use of yesterday's opening ceremony of or launching ceremony of Hong Kong TV? In fact, they were trying to make use of that occasion to attack the CE. So could we also say that there was a conflict of interest? Could we also say that personal interests were also involved? The Pan-Democrats would say, of course not. So we should be fair. You must have substantial evidence before you point a finger at others. You cannot just call names as you like. I will reiterate that the uncooperative movement started by Pan-Democrats, and which is featured as a filibuster in the council. You are pulling the leg of the administration all the time, and the lever, as well as civil service pay adjustments, cannot be effected. Is that responsible behavior? Are you working for the interests of the public, or are you standing on the opposite side of the public? Lastly, I'd like to say that starting with the Occupy movement, the Pan-Democrats have been supporting the illegal occupiers, including allowing the occupiers to stay the night in the council illegally. And they are telling occupiers not to heed the injunction orders. They are encouraging people to break the law. They are trying to paralyze Hong Kong's economy in order to achieve their aims. Yesterday, some protesters stormed the LegCo building. Pan-Democrats immediately said that they had nothing to do with it, that they were not the people working behind the scenes. But the protesters had ignored law and order totally, and the Pan-Democrats have unrelinquishable responsibility behind this. If the Pan-Democrats will not stop their uncooperative movement, they will eventually be abandoned by the public. So I speak to object to the motion moved by Ms. Cyd Ho.
Mr. Albert Ho, Mr. President, today and 2 weeks ago, and we moved the motions hoping to invoke the P&P Ordinance to probe C.Y. Leung's declaration in relation to the purchase of DTZ by UGL. And this has to do with his declaration of interest. It has a great ramifications, and it has to do with whether our system can uphold a clean political system in Hong Kong, and also whether we can prevent corruption. So this is the motive, our motive for moving these motions. 2 weeks ago, we first started with invoking the P&P Ordinance to probe the UGL's acquisition of DTZ's business worldwide. And at that time, we didn't mention specifically about DTZ Japan. But then in the past 2 weeks, we saw that actually C.Y. Leung has not declared his interest in DTZ Japan. And in the whole matter, he has great conflict of interest, and he didn't disclose his interest to the public. And for the £5 million, well, that will be an under-table commission and not an amount paid out of a golden handshake. I'm not going to repeat what was said 2 weeks ago. For this second part, our focus is on the sale of DTZ Japan. Before I give my analysis of the situation, I have to first respond to the CS's remarks just now. She emphasized that the CE and members of the LegCo are subject to a rigorous declaration of interest system, and the CE has strictly adhered to this declaration of interest system. I have great reservations on these 2 points. First, is it a rigorous declaration system? I have great doubts about it. There are 2 sets of guidelines or systems by which the CE must adhere to. And that first is the declaration of interest system for the LegCo members. And it seems that C.Y. Leung has declared his interest in accordance with this system. But in paragraph 2, it says that to ensure that LegCo members offer unbiased and impartial advice to the chief executive, and the LegCo members have to make the relevant declaration. But then the declarations are made with the chief executive himself, and many of the things have to be approved, so to speak, by the CE. And he is the person who is vetting on what can be done and what can't be done. So the system is not very clear. And what is more important is that we have guidelines on politically appointed officials. And in it, there are details on how to prevent conflict of interest. But how much of that is applicable to the CE? I remember that Mr. Andrew Lee, the former Chief Justice, had compiled an independent review and report on preventing conflict of interest. And it says that the CE must also be bound by this guidelines on the politically appointed officials. But then, in a response to an oral question in 2013 to the LegCo, and she only said that, well, the CE should try to abide as much as he can, if applicable. So that begs the question of what do you mean by applicable, and when should he be abiding by the guidelines? Chapter 5, paragraph 5.5. It says that and during the tenure, unless approved by the CE, the politically appointed officials could not be a director of a company and to directly and indirectly participate in any activities of a company, association, public or private, and also chambers of commerce, trade associations, etc. So unless he gets the approval from the CE. Now, coming back to 2 weeks ago, we said that the CE received a sum of money and he was supposed to provide a service. And we said that this is a sort of remunerated task and that he must declare it. But then in paragraph 5, it says that the CE can give approval not to make that kind of declaration. So the CS said that he is not contravening that guideline because he approves him that he should not be abiding or declaring that interest because he is the one who makes the decision. So this is exactly the loophole of the system. There are so many loopholes, and this is only one of them. That's the first point. Second point, we also told Mr. Andrew Lee that if we just declare the assets, not the liabilities, and that's a danger. Well, perhaps he has assets, but then that's negative assets, and he has more liabilities than assets, maybe. And if the CE has a lot of liabilities when he assumes office, then he would be sort of ingratiating his creditors. So regrettably, then that point was not tackled. Now, third point about declaration. In the EXCO's declaration of interest system, it is said that if a person has a more than 1% of beneficial interest in a company, a declaration should be made. I think the spirit is very clear here. If a person can transfer all his shares in a company to an overseas company, be it a BVI or Cayman Island company, and then holds the shares in 10 or even 100 companies, property agents, companies, and so on. And then he comes out in the public and says that I'm not involved in these 100 companies because these 100 companies are subsidiaries of Wintrack. And then I declare Wintrack, but nobody knows what's Wintrack is all about, what it is doing. So what use is that of such a declaration? I don't think that is the spirit of the declaration. So if later on the CS said that he doesn't have a problem with declaration of interest because he has declared a Wintrack. It is a nominee company and it's maybe a trustee company, and whatever it holds really doesn't belong to CY Leung, so he doesn't have to declare it. Well, is this the spirit of the declaration system? If that is, then, well, that kind of system is of no good at all. It is a deceitful system. So, CS, can you tell us, really, from the bottom of your heart, that he has not contravened the declaration system? And he has not gone against the requirements, which says that he must declare any interest which is over 1% of the interest of the company. And now Mr. C.Y. Leung has never declared his interest in DTZ Japan, and that's very clear. Well, the incident has been exposed recently, and we've looked at all the documents, and our estimate or guess is that he has a 30% of the shares in that company. And in the future, if he has to exercise his options in the future, he will be getting £200,000 and also 30% of net audited profit after taxation for the next 3 years, or pre-profit tax. So this is our guess. Can you confirm whether this is true or not? Well, if it is a fact, it is true, then it involves 2 points: whether he has declared it with the Chief Justice, and also whether he has declared it within the EXCO, because a conflict of interest may be involved. And I believe that the CS will not deny that in the guidelines on politically appointed officials in Chapter 5, there is the mention of conflict of interest. Any politically appointed officials should avoid being suspected of having a conflict of interest and not being impartial and so on. And the politically appointed officials should be fair. And thirdly, they should not deal with issues that have a substantive or that they have a substantive or potential of a conflict of interest. Now, the case is clear. C.Y. Leung holds 30% shares of DTZ Japan, while he himself or his wife, and that is valued at least £200,000. The DTZ Japan is still running business activities. Hong Kong Resort is a client. Hong Kong Resort is a big listed company in Hong Kong, and as we all know, it is once a major shareholder of ATV, and when the ATV's licensing issue was being dealt with, even when the Hong Kong Resort sold off its shares on ATV still owed a great debt to Hong Kong Resort, and that debt could be turned into shares. So this is a kind of credited sort of liability, and is a sort of big creditor of ATV. So in that case, well, it is in his interest to make sure that ATV still holds a license and still runs a business. So is this a direct or a potential conflict of interest? I think the test is simple. If C.Y. Leung is still a partner of a valuation agency, and say if there is a judge dealing with this case, and one of the parties to the case is Hong Kong Resort, and the Hong Kong Resort has this interest with this company, it is a client of that company. Well, should C.Y. Leung be judging on the case? Well, the test is as simple as that. Well, some people say that the relationships are rather remote and the amount involved is not that huge either. Well, you can argue, put up arguments like those. But then if we are really asking for impartiality here, well, does it mean that some $2 million is just too small for us to pay attention to? Well, we study law, and we learned that a judge once ruling on a bank's case was found that he did have some shares in the bank. So the ruling has been overturned altogether. The judge said that he couldn't remember because the amount of the shares and the value is too small. But anyway, the rule of law is this, that it is not just, it doesn't suffice that you think you are being impartial, but you must give the impression that you are being impartial. So this is something that we are very worried about. How come that he didn't declare such interest? Let's not talk about the investment in Lantau. That's something else. And perhaps Ms. Ho will talk about it later on. So under this case, well, we have every reason to understand more, to try to find out more. I think the scope proposed for the investigation is rather narrow here. I think we should also open the Pandora box, so to speak, of WinTrack, and we can, more things can be revealed. But anyway, well, let's find out the details before we can see how we can move forward. Rules of Procedure 17.2, quorum count, please.
Dr. Kenneth Leung, please. Thank you, Mr. President. Well, first of all, I'd like to respond to the points raised by the members from the pro-establishment camp. That is that this PNP motion is a tool to overturn the CY Leung administration. I cannot agree. If any member has seen my article in Singtao News and Economic Journal about the questions I raised over the UGL dealings only on legal matters, even if CY Leung were not the chief executive, all the everything in this UGL transaction was very problematic. The question is whether CY Leung had acted in accordance with the listing rules, the company's ordinance, etc., to perform his duty as a director of the company and be accountable to major shareholders, minor shareholders, and other directors, and the major creditors of DTZ and the administrator, whether he has performed his legal obligations and moral obligations. Well, one of the articles was published more than a month ago. The other article was published yesterday. However, nobody from the pro-establishment camp responded to my articles. Not anyone, not any accountant or lawyer. All the points raised in my articles were based on business ethics and law. Well, some say that this is mudslinging. This is part of the non-cooperative campaign. In fact, the campaign arose from the business transactions as set out in these 6 pages. There are 2 parts to Ms. Cyd Ho's motion. The first part has to do with Article 47 of the Basic Law, which stipulates that the chief executive must be a person of integrity, dedicated to his or her duties, and on assuming office, I emphasize these words, the chief executive, on assuming office, shall declare his or her assets to the Chief Justice of the CFA, and the declaration shall be put on record. This is one of the key issues in this motion to invoke the LegCo PNP Ordinance. Now, on these 3 words, on assuming office, I'd like to ask, how many months or how long did it take for CY Leung, on assuming office, to declare his interest to the Chief Justice of CFA? We have no idea. Was it after CY Leung dealt with all the shares he held so that those shares could be put on trust before he made the declaration? Let's talk about this later. On the 29th of October, Chief Secretary Mrs. Carrie Lam, on answering the urgent oral question put by Mr. Albert Ho, said that Mr. CY Leung had already made his declaration according to the Basic Law, and there is no definition of assets in the Basic Law. And on grounds of privacy, this declaration remains confidential. Chief Secretary, my question is this: can we exercise our common sense, or as a matter of business practice, or in accordance with the company's law, consider what assets mean? We all understand what it means. And in Article 47 of the Basic Law, despite the simple meaning of the word, you say that it's up to CY Leung to decide whether to declare or not, because there is no such definition in the Basic Law. And Chief Secretary, what are the reasons for keeping it confidential in light of, or in public interest? Should public interest override the rules of confidentiality, and that the declaration should be disclosed? This is the question I'd like to ask under Article 47. The other point I'd like to speak on is the form for LegCo members to make the annual declarations of interest. According to Mr. Cyd Ho's declaration, item 5 stipulates that an executive council member shall declare beneficial shares held by the member or his or her spouse. So, Mr. President, the term used is not legal owner of the shares, but beneficial one. Even if Mr. Cyd Ho transferred all the shares to a company and hold the shares in trust, he is still the beneficial shareholder. And it is in fact a big envelope. We have no idea of how many shares being held in trust by this company. However, according to this declaration form, he must also set out in detail the shares held by each and every company owned by him. Otherwise, the whole declaration system would be meaningless. So be it LegCo members or LegCo members, it's very simple. Just spend several $1,000s to ask a lawyer to prepare a trust so as to hold millions of shares, and then you can say that this is the ABC trust and I have no control over this trust. And that's it. But then what is the meaning of this declaration system? So, Chief Secretary, please explain to us about Chapter 5 of the System of Declaration of Interest for members of the Executive Council. What is meant by beneficial shares? Please, I hope that you could respond to us what it means in your reply later. Now let's turn to the UGL agreement. The doubts, the comments I made on the UGL deal actually arose from the 6-page agreement. How come Cyd Ho never came out and say that it never happened? And that's the end of the matter. In fact, on page 4, it says,
those shares for up to 7 years from completion. That
means in fact, the option to sell the shares is still valid for Mr. Cyd Ho because the agreement was signed on the 2nd of October, and the completion date of DTZ was in the beginning of 2012. That means the option to sell the shares would remain valid until 2019. So now Cyd Ho is still benefiting from the options. And what is the value of the options? Paragraph 4 of page 4 says so very clearly that the minimum value would be £200,000. That is $2.4 million, Hong Kong dollars. However, despite the fact that the minimum value is £200,000, the maximum is in fact without limit. That is pre-tax. It's pre-tax value after deducting the expenses for interest and the pre-tax profit and depreciation value for 7 years times 30%. Well, that means it could be millions or billions of dollars. That means he could receive a minimum amount of £200,000 or 30% of the EBITDA of this company. That means the more business this company did in Japan, the more beneficial it would be for Mr. Cyd Ho. This is the direct monetary interest. Now, Ms. Cyd Ho, in her motion, raised an example of Hong Kong resort, but this is just one of the examples. In fact, we all know that many property developers in Hong Kong would invest in property projects in Japan, and because DTZ Japan is a private entity, our understanding from the media reports is that HKR is a major client of DTZ Japan. But is it the only client? Were there other major developers who were also major clients of this company? Or even the sole client of the company? We have no idea. If there were one or two companies, local companies, which were clients of DTZ Japan, why would there not be a conflict of interest? As I said, the more business DTZ Japan did, in 7 years' time, CY Leung would, the more money CY Leung would pocket in 7 years' time. So if there is no objection, I will deduce further. If this company in Hong Kong has a lot of business transactions in Hong Kong, if government policies are involved, then when making policy decisions in the Executive Council, shouldn't Mr. CY Leung declare his relationship with DTZ Japan? Because as this company continues to be a client of DTZ Japan, the more money Mr. CY Leung's pocket will have. This relationship is very clear. Let's say if a client wishes to table a private bill in the council, then why shouldn't I make any declare any interest if that company is my client? This is direct or indirect pecuniary interest, and this is exactly direct pecuniary interest. Never mind what political motive there is behind. Just now, a lot of members from the pro-establishment camp told me that we have Article 47 of the Basic Law, and the LegCo Powers and Privileges Ordinance should not be used to investigate the chief executive, because there is a power under the ordinance to veto the chief executive. I support the under Article 73 there is an impeachment power. Therefore, I feel we should understand the matter first. Well, if we resort to Article 73 to impeach a chief executive without considering the matter in great detail, will be criticized by you again. That is why we propose that a select committee be set up to get more information first. Of course, pro-establishment camp members would dominate this select committee. But the point is to find out the truth of the matter. The CY Leung and his administration, after the publishing of my 2 articles, failed to respond directly to my questions. Even worse, they never responded to media questioning. Is this the best way or the best attitude to face these issues? My answer is no, Mr. President. That's why I appeal to members across the political spectrum to consider seriously this motion to invoke the LegCo PNP, and I support the motion.
The Honourable Chen Han-pan. Yes, Mr. Albert Chan. Quorum count, please.
杨班议员，你先等一等。
Please wait. Mr. Chen Han Pan. Thank you, Mr. President.